Hi, I-485 is under fire. Is adjustment of status still safe? Today, I wanted to briefly explain the new USCIS I-485 policy memo and who will be most affected. This is the memo. This memo does not abolish I-485. What is I-485? I-485 is adjustment of status, which means it is the last step of your green card application. And if you are physically in the US, you file I-485 adjustment of status with USCIS, adjust your non-immigrant status to immigrant status. But today, USCIS says in most situations, you should not do I-485 in the US. You should go back to your home country, go through consular processing, applying for immigrant visa. But who will be impacted the most? Under INA 245, people who are legally eligible may still file I-485 in the United States, but the memo changes the tone of the review. USCIS now emphasizes that adjustment of status is a discretionary, an act of administrative grace, and an extraordinary relief that allows an applicant to avoid the ordinary consular visa processing abroad. So the question is no longer only, am I eligible to file I-485? The new question will become, why should USCIS allow me to complete the green card processing inside of United States instead of requiring me to return abroad for consular processing? So who is most affected based on this memo? Tourist visa entry followed by a marriage-based green card. If someone enters US as a B1, B2 visitor visa, this visa itself requests temporary stay and non-immigrant status. So if you later marry US citizen, in the past, you could file I-130 and I-485, stay in the US and wait for your green card. But under this memo, you can no longer do that because your filing I-485 is against your visa. Your visa asking you to temporarily stay and without immigrant intent. So you will need to go back to your home country, wait for the consular processing. Tourist visa entry follow EB5 adjustment status. This category will also be impacted for the same reason. B visa enter US is for temporary stay without immigrant intent. Under this memo, you cannot file I-485. You could submit I-485 as a procedure, but your I-485 probably will be denied because of this memo. The third is F1 student, OPT, STEM OPT. Your F status request temporary stay and non-immigrant intent. So if you are F student, you can no longer do I-485 based on your EB1A, EB1B, NIW, or EB5 for the same reason, because your current status requests non-immigrant intent. And then another group of people who holds TN visa, E visa, J visa, and other temporary visa. Those kind of category does not specifically say non-immigrant intent, but it does not either specifically say allow immigrant intent. So if you are holding those kind of status, it's a very vague area. Whether you could do I-485 depends on what kind of extraordinary situation you are in. Then employment-based application, if you are holding H1L, because your visa allows you to work in the United States and specifically allow immigrant intent. So if you are holding H and L, you probably have the best chance to do I-485 under this memo because filing I-485 is not violation of your current status. And if you are doing family-based, for example, you are US citizens, adult children, or US citizens, adult married children, or US citizen sibling, the waiting of the green card is long. So usually those kind of family-based applicants, they are overseas outside of US anyway. So for them, I would suggest you wait outside of the US for the consular processing. So under this memo, the people who enter US as a visitor visa later on go through marriage-based green card, later on go through EB1, extraordinary ability alien green card, or later on go through EB5, investment green card, would no longer be able to do that under this memo. So what would happen if this memo takes effect? Am I still allowed to file I-485? Or if my I-485 is pending, what would happen to them? Under this memo, you are allowed to file, but there is a very high chance that your I-485 will be denied if you are in the high risk category, such as you're holding B visa, you're holding F visa, you're holding J or TN visa. If you already file I-485, your I-485 is pending. It will also be impacted by this memo because this memo was announced today and it will take effect. And USS believes this memo is just an explanation for the current law. So it doesn't need to go through certain procedure to collect public comments. So when the memo takes effect, it will impact all kinds of I-485, no matter you submitted it or you have not. For the I-485 who is pending, go back to your visa history, see if you have visa violation, see if you submit I-485 while you are holding a status request non-immigrant intent, see if you have any immigration visa violation, any criminal record, any arrest record. If you have those complications, please make an appointment with a lawyer. Let a lawyer evaluate the risk of this I-485 being denied. Then you have to go through consular processing. So if you have not submitted your I-485, I would strongly suggest you find a lawyer to evaluate if you could adjust your status in the US, if you are in a high risk category or low risk category. Why all of a sudden on a Memorial Day Friday, this policy comes out? Looks like all the bad news comes out on Fridays. Whether this memo can legally stand, that's the question lawyers are talking about right now. So the government has one strong argument that this INA 245 has always been discretionary. It's always discretionary. It's just in the past, everybody was going by default that if you are physically in the US, you can adjust your status. But now US says, raise the bar, saying, hey, it should be a case-by-case discretionary review. And only when you have extraordinary circumstances, the officer will give you the admission grace to let you adjust your status in the US. So this is the bar we can interpret as additional requirements for the adjustment status that the statute doesn't say it. So we're waiting to see if there is any lawsuit filed against this memo, because this memo has very meaningful impact to all the immigrants who have been staying in the US under F visa, under working visa. Their path to green card without leaving the country could be terminated because of this memo. Another more meaningful impact is if everybody is requested to go through consular processing for the last step of their green card application, the consular processing will be enormously crowded. Huge caseload. They cannot process in so many immigrant visa applications then what will happen? They could not process as many as possible, and they could not consume the quota assigned to the green card every year. So the waste of the immigrant quota will be a huge problem. And the real meaningful consequence is, without going through Congress, reduce immigrant visa quota, the administrative delay itself will trigger the result of waste of the immigrant quota. So the reduce of immigrant quota can be achieved via administrative delay. This is just the first day of the memo. We're waiting for more details from the government. And we're going to give you updates in this channel. Please subscribe and give us a like. We're going to have more coming out. Thank you.